Court is now open. You may be seated.
No case number 3844 versus Sex Offender Registry Board.
Mr. Less, welcome back.
Thank you, Your Honor.
Thank you.
Just for the record, Daniel Less, I'm the Special Assistant Attorney General representing the Board in this case. In this case, Your Honor, the Board classified plaintiff as a Level 2 sex offender after a hearing before a Board hearing examiner. Plaintiff exercised his right under Chapter 6, Section 178M to seek judicial review. The Superior Court initially remanded the case back to the Board, finding that the Board's regulatory factors did not provide a sufficient procedural due process to the offender to render a decision. The Board filed a motion to reconsider. On acting on the motion to reconsider, the Board issued the Superior Court issued an order reversing the Board's decision and reporting the question to the Appeals Court whether the Board's final classification procedures vests untrampled discretion in the Board over the classification level, thereby rendering the procedure one that is arbitrary and contrary to law. This Court took the case sua sponte from the Appeals Court.
Can I ask you a question on a 30A review of a classification decision? Can the Superior Court judge reduce the classification level, or does he or she have to send it back?
It's the Board's position that it should be remanded back because because the ultimate decision is a question of fact, and it should go back to the fact finder to.
So if the judge, for example, finds that the current classification is unsupported by substantial evidence, the judge would not lower the classification but send it back?
That would be the Board's position. I will tell you that some judges have reduced the classification level. One such case is on appeal in the Appeals Court right now. But it's the Board's position that the proper remedy is a remand to the Board to review the evidence in a light consistent with the Superior Court's decision on the 30A standard.
So what happens to the untrammeled discretion question?
Yeah.
I'm sorry?
What happens to the, quote, untrammeled discretion question?
I distracted him.
Or putting it differently.
No, I mean...
Yeah.
Well, the question,
why can't you assign, which sort of plays into this, what's the difficulty with assigning some kind of weight or numerical factor to each of all these different criteria, much like sentencing guidelines, and if you get a certain score, you're level 1, certain score, level 2, so on. What's so bad about that?
Well, I think that the question is under a procedural due process test, as articulated in Matthews, really looking at the second prong. Is it necessary? Does it result in a more accurate decision, or do the existing procedures?
Well, you could have the same case go before two different hearing examiners, and one would classify someone as a level 1, and the other guy would classify him as a level 3. It's possible, right?
But doesn't that happen all the time in sentencing? Depends what judge you go before. You could get 10 years, or you could get 2.
Well, and that's why part of in looking at this analysis, one of the important things is 30A review, and whether or not in the ultimate decision is whether the decision was supported by substantial evidence. And that really is the ultimate question in terms of procedural due process. Adding a point system, ultimately, you're going to be, well, two things are going to be happening that might be problematic to answer the initial question. One is designing such a system that would account for all of the various nuances that the Board's factors encompass. That is a difficult and time-consuming...
Well, how could we as a court require a point system anyway? Even if we decided for some reason that this was an unlawful delegation, how could we say you've got to have an arithmetic one? Isn't that a legislative decision?
I think, exactly. I think I think it's a decision that's left to the discretion of the Board, and the Board's...
Well, it's not left to the discretion of the Board. It would be... I think it would be the legislature. Maybe if lawfully delegated to the Board, but it certainly wouldn't be for the court to say you've got to have an arithmetic.
I would agree with that, Your Honor. And the legislature here, in enacting the law, granted the Board a pretty broad discretion in terms of how you want to design your guidelines, and the Board looked at those factors that they said, and the board put together very detailed and specific regulatory factors that guide hearing examiners in these cases. The appeals court recently described them as, in the Smith versus SORB case, it's a case that I don't cite. I cited in my reply brief here because it was decided after the board's primary brief. But describe those factors as detailed and specific, certainly a lot more detailed and specific than you see in a lot of other similar type of schemes that, say, parole or any other agency use, and that the hearing examiner looks at those factors and sees whether the evidence matches the various elements of those factors, and then weighs the evidence in a fair and reasonable manner.
But how do you respond to Mr. Smith's argument that this isn't the same as parole or probation, because the defendant there has been convicted and he's still under the conditional liberty, if you will, and here he served his sentence?
Mm-hmm. Well, I think it is a conditional liberty, but it really goes to the first factor of the Matthews test. What is the interest? What is the liberty interest? What is the interest that's at stake? And while it's a conditional liberty interest, it's a real liberty interest one way or the other. It's a question of restraint, a question of whether or not this person is actually going to be released from incarceration, which I think involves a much more serious, much more higher level of an interest or a right than what's at stake here, which this court has indicated as a relatively limited liberty interest in terms of issues about reputation and future earning capacity and employment. I mean, he is an offender who is facing, perhaps even at sentencing, whether he will in fact be incarcerated, or on a question of bail, or on a question of probation, or parole, and they're actually facing an actual liberty interest. There is no such required use of a point-based system, and fact finders are entitled to use their good discretion and sound judgment in making these decisions.
So the case comes up to the Superior Court. The judge looks at it, sees that the examiner has considered 18 factors, 10 sort of weigh towards minimizing the risk, 8 increasing the risk, but the examiner classifies the person as a level 3. Mm-hmm. How does the judge go about assessing whether there is substantial evidence? How does the judge go about figuring this out? Well,
I think the judge looks to this court's what this court has said about what substantial evidence is, in particular in the Coble case. Is there an overwhelming? Does the evidence, looking at the entire record, point to an overwhelming probability to the contrary of the decision that the hearing examiner made? For example, if you had an offender who, has a relatively minor sex offender history and has been in the community for an extended period of time without committing any offense and is engaged in a plethora of rehabilitative efforts and is classified as a level 3, let's say he just committed 2 open engrosses, has been in the community for 15 years without offense-free, and the board would have classified him as a level 3, I think a judge would be rightly entitled to conclude, well, the evidence points to an overwhelming probability to a different conclusion. But where reasonable minds can differ, and the board is entitled to the benefit of the doubt in terms of the decision and the credibility determinations that are made on the ultimate decision. So there is a substantial 38 review is just not a rubber stamp of the hearing examiner's decision. It has to be supported.
Let's say the record indicates, as I think there's some suggestion in one of these cases, that the hearing examiner simply didn't consider some factors that would reduce the risk. Mm-hmm. So the judge says, okay, I have this. I hear the hearing examiner has considered 10 factors, but there are 5 others that apply here. There are 4 others that apply here that haven't been weighed. What does the judge do? Arbitrary and capricious?
That issue is in the case that's coming up next. As far as the unapplied factors go, I would suggest if the evidence, you got to look at the evidence and to determine whether or not the factor was applied appropriately or not applied appropriately.
Or not applied at all.
Or not applied. If it wasn't applied at all, it might not. You don't have to apply every single factor. I mean, the fact that.
But if it's an obvious factor that clearly is if X then Y, and it's not been put into the calculation.
Then that might be one ground for remanding the case. If there was evidence that supported the application of a factor and the hearing examiner didn't, and it was a significant factor. certainly that would be, the board in essence isn't following its own regulations, and that would be grounds for that would be another ground. Another reason it happens, you could say, is if a factor is applied that shouldn't have been applied, if there was a factor that was misapplied, or the evidence didn't support the application of
Mr.
factor.
Less, I mean, I understand your argument here, but as I understand Judge Kane's concern was that the board has listed a series of factors, but that, in his words, the regulations fail to describe any specific role for these factors, so that, I mean, essentially what you're saying is if the petitioner can come in and show that the judge overlooked some factor, I suppose the answer from the board, at least as presently drafted, would be, but he wasn't required to look at every factor. The factors are guidelines. They are there for the hearing examiner to consider, but there's no specific role.
I think that there is.
I'm trying to get to the legal challenge of, regardless of whether you have a point system or you don't have a point system, I think Judge Kane is saying, stripped of everything else, bottom line, it's just the hearing examiner's sort of impression. And I can't evaluate on a 30A review, a decision which is based on an impression. I think that's what Judge Kane was saying.
I think that's part of it, that he's looking, that as Judge Kane says, that there should be some sort of presumptive standards in terms of what the factors should be. The problem is that it is, and I think the problem with that analysis is that it's an individualized hearing based on the individualized evidence in that case, and the evidence in each individualized case is going to be different in terms of the interplay of the factors.
It is going to be different, but I think that unlike sentencing, there's no sentencing is society's determination of what is an appropriate punishment for this kind of crime. Then there are all kinds of discussions about whether you can rehabilitate people, you can't. That's different. That's just punishment. And if the legislature wants to have the death penalty, the legislature has a death penalty. In other states, the legislature says, no, we want life sentence. Nobody's saying that you can't do that.
Okay.
Here, essentially, what you have is a classification which is based on a theory of predicting somebody's behavior. I mean, that's what underlies all of this. It is not further punishment. We are not punishing you. It's for the safety of society. And if there is compelling evidence, for example, that overwhelming evidence on very, very good scientific studies that nobody challenges, that after a certain number of years, if recidivism is to occur, it will occur within so many years after the last offense. I think, as I read the petitioner's claim, in essence what he's saying is not that you have to be bound by anything, but you have to you have to give something other than I'm left with an impression. So here, I read these cases and I can't remember all of the facts, but I think the last offense was in 1992, and yes, of course, there was a series of offenses, but they were clustered around the same time, and this person who was a young person is now grown up, he's out of a family situation, and essentially, there's nothing in the regulations that say to the hearing officer how much weight, if any, you should give to that. This is not punishment. This is not total discretion. No. This is predictability. So one, hearing officer says the last time this person committed any of these offenses was in 1992, and maybe it's now 2022, and I've taken that into account. Nevertheless, I conclude that he should be classified as a level 2. I think that's the thrust of the argument.
Mm-hmm. And I think that there's two issues with that. There's, first of all, as the appeals court recently indicated, and I cited in my brief in the Mass General Hospital case, when you're trying to develop a regulatory system, you need to look at the type of thing that you're looking to regulate. And you're talking about assessing risk, which is a very nuanced fact-based, fact-intensive question.
But it is susceptible to certain guidelines. When you're assessing risk of anything, you can't simply say, well, because there's a risk, it's nuanced, and therefore there's unfettered discretion.
And there's not, because one of the things that the hearing examiner has to do, as he did in this case, is write a detailed decision explaining what factors he applied and why he concluded that the factors and the interplay of the factors reached the conclusion that he did. And in other cases, in other contexts, as I've cited in my brief here, that providing that level of details this Court required in the, I think it was Doe 4.
Forgive me, but it's not unusual, for example, in other areas where there are property interests involved, not liberty interests, that, for example, there are all kinds of studies that show a certain amount of emission of something or other is going to cause these kinds of risks. And essentially what we try to do is to have a reasonable process where the discretion of the regulator is cabined in some kind of way. And so you set standards so that everybody knows it can't be, well, I understand, I've heard this expert, I've heard that expert, but I just have the feeling that carbon monoxide, shouldn't be permitted in this building, and so you condemn the building. You can't do that.
Well, and I think that's exactly what, in the Mass General Hospital case, in citing the cases of this Court, is saying, is that there is certain context in those cases where you can make those determinations, but that doesn't work well in a situation in these type of cases.
Why?
Because, well, first of all, you could look at
You've got a growing body of evidence on recidivism. We're talking about recidivism, aren't we?
Well, even if you look at plaintiff's brief, his well, first of all, he hasn't made any showing that any of these cases, it's his burden that it would increase the accuracy. And there's a lot of debate about what he, in terms of the actuarial assessments that he wants to include. Amicus files a brief that says, well, we don't want to use actuarial assessments. We want the board to develop their own system. We don't know what that system is, but we don't like what you're doing. We want you to come up with your own system. And the board struggled with these, looked at this, and using the board's expertise, came up with a detailed set of guidelines that put offenders on notice in terms of what are the areas that the board is going to be looking at, what is the board going to find significant. So the first 6 factors are designated as high-risk factors, and that certainly indicates, as both the legislature and the board have said, that the presence of those factors is important and weighty. And the interplay of the other factors is simply going to depend upon the evidence and using the good discretion of the hearing examiner in relying on the factors, not relying on his own knowledge or some other knowledge. He has to rely on the regulatory factors, and that is subjected to judicial review under the substantial evidence question, that the decision has to be logical and well-reasoned and grounded in the regulatory factors, and that satisfies due process. I see I've exceeded my time.
No, you've been responding to our questions. You didn't exceed your time.
Thank you, Your Honors.
Mr. Lester.
Unless there's any other questions. Thank
Mr.
you.
Smith?
Good morning, Your Honors. May it please the Court, my name is William Smith, and I represent John Doe in this case. The cornerstone of this case, the cornerstone of the issue is relative to decreasing the risk of erroneous deprivations, and that is nothing. I'm not standing here before this Court asking this Court to substitute its judgment over that of the legislature.
How do other states handle this? Have you sort of looked around? And
Your Honor,
New Jersey did it one way.
That's correct. And most of what I have found in my research dealt with more sort of the other states' sexually dangerous person statutes rather than their sex offender registry board paradigms. Again, the literature is clear, however, and we touched upon this earlier, but the literature is clear that an actuarially based system combined with a clinical system is what the literature calls it, but a more subjective approach, that it's the combination of those two paradigms is the most accurate. The Hansen and Bussier study, which is not just a single study, it's a meta-analysis of the literature in this area, tells us that the correlation coefficient that they found was actually almost a 0.5, whereas the subjective model, which is what we are now using here.
Why do you say it's a subjective model when they have this list of factors, objective factors that have to be applied? Because the examiner can decide which one, and 6 of which, as I understand it, are to be weighted more than the others.
Well, that's the problem, though. The problem is in the application. The problem is not the factors in and of themselves. The problem is, as the Superior Court judge ruled in this case, is that it leaves unfettered discretion to the examiner.
What would happen if they assigned points to the things and you disagreed with the points they assigned? Let's say the top 6 are the bad ones, and they say, okay, if he's done any one of these things, he gets 7 points. And he does 5 of them. That's 35 points, and then you go to the score sheet, and 35 points makes you an automatic level 3. So they, the points, you don't like the points. Why are they giving 7 points for that one?
Well, that's precisely why our argument here is that it's not strictly an actuarially based system that would satisfy due process in this case. It is one that is combined with a clinical or subjective.
Because an actuarial based system really tells us nothing about the person sitting in front of us. It
Right.
just
That's
tells us
correct.
generally
That's correct.
about the population.
That's correct.
Similar.
And I am not arguing that an actuarially based system in and of itself is what is required.
Have we ever required for a lawful delegation that the legislature create an arithmetic ratio of importance?
Well, number one, that is not specifically what I'm arguing for. Number two, not that I'm aware of. And number three, this is an entirely different new realm of constitutional jurisprudence, I would suggest.
Well, but we apply the same constitutional concepts that we've always applied, and here it's a question of a lawful delegation and the exercise of that if the delegation is lawful, number one, and if it is, then whether the board's procedures in making the decisions in accordance with the standards are rational and give the registrant the process that he's entitled to.
Your Honor, however, again, the difference here, as I noted in my brief and as Chief Justice Marshall had touched upon, the difference here is the state is engaged in an endeavor that seeks to predict future behavior, and it's entirely different. It's an entirely different construct from sentencing, parole, bail, decisions, et cetera.
Is it really?
Is it?
When a criminal sentence is handed down, isn't that exactly one of the elements they're trying to do? Predict future conduct?
It's one, but it's also retribution. It's also
Well,
But what about bail?
safety.
Bail,
This
the
is true.
prime element in bail is whether he's likely to reappear. That's predicting future behavior.
But again, the
Totally
liberty
what it is.
interest at stake, as the entire line of Doe and Roe cases from this court has suggested, the liberty interest at stake is quantitatively and qualitatively different when you're talking about this endeavor.
Mr. Smith, to get back to the legal question, not the comparisons with other systems, I take it from your response to Justice Cowen that you are not challenging that there has been a lawful delegation to the board. The scope of the delegation, but that there's been, in other words, it was perfectly appropriate for the legislatures to say to the board, figure it out, right?
Correct.
Then we go to whether or not, there is something irrational, wrong, impermissible about the board system. And as right towards the end of his discussion, Mr. Less said, the board has struggled with this. This is what the board has come up with. You proffer one thing, the amicus proffers another thing. What is it that, as a matter of law, tells me that I must select from among those, as opposed to saying that there's nothing here that shows that what the board has done is impermissible? It may not be the best from your point of view, but it's not impermissible. Because
I think, as the Superior Court judge's concern was here, although it wasn't perhaps said as succinctly as this, but it's under Matthews v. Eldridge, it's the risk of erroneous deprivations. Mr. Less my brother had also mentioned the point system, and the problem with the point system is that it's going to create all these problems. Well, the SWORP has a point system right now. They utilize an objective point-based system.
I have to tell you, I looked at the worksheet. I couldn't figure it out. Can you explain how the point system worked on the worksheet?
It's true. It is confusing. However, it's an allocation of an objective point-based system for that initial classification, and where a
So how many points did your client get on the worksheet?
The record appendix, I was looking at that last night. The record appendix, the portion that I have, I really cannot even discern it.
There's sort of a point section someplace, and then there's a whole bunch of factors, and then it says level 2. I can't, I don't
Correct.
see that this is a discipline point system where you add up and you have a grid. I don't see that here.
From my experience, speaking outside the record, from my experience, that is what the board utilizes relative to that initial classification.
So they assign numbers to each of these factors, 23 factors? I don't see there's even a place to assign numbers. So yes, there's a system here. Yes, there are some points at some level given to some things, but this is hardly a detailed point analysis. This is hardly a grid of any sort.
Well, again, and one could argue that perhaps the rationale behind that is the fact that that is the initial classification system, and certainly, as Mr. Les touched upon, then the former offender has the ability to challenge that by way of a final hearing. But again,
Sorry, finish that.
Again, as Judge Kane had mentioned in this case in his decision, it is indeed anomalous that we have that prior initial classification system that, whether it's ambiguous somewhat or not, does seek to utilize such a weighted factor system, if you will. Yet then at the final classification stage, we have this sort of qualitative analysis, as the board examiner called it here.
Assuming that we accept the board system, and assuming that we've got a 30A review, are you telling me that there's no way that a judge in the Superior Court can evaluate a determination to see whether or not it's supported by substantial evidence?
I think it makes it exceptionally difficult.
Well, it makes it difficult because, as in this case, this was a close call, correct?
Correct. Correct. My client had one offense. There was some discussion about that earlier. There was one index offense, which I believe was 1992. And again, and to give an example of the confusion here, he was faulted for the fact that he was going to college insofar as being in college, the board examiner found, subjected him to being surrounded by young women, yet at the same time, the application of these factors as we now have them resulted in the board examiner saying, well, that's a plus in his favor.
Well, I think a court can look at that. Can't. In other words, I'm trying to, foresee, let's assume that you had an actuarial and a clinical or subjective, and then you still got a Superior Court judge who's going to determine whether or not the classification is supported by substantial evidence. Is the Superior Court judge going to be in a better position? I mean, it seems to me what you're saying is that it's the mechanism of classification which is at fault.
Correct. And yes, Your Honor, I do think the Superior Court judge would be in a better position at that point. Well, because at least one part of the puzzle, if you will.
What you would get is some whole bunch of objective stuff, and then you would say, well, now I've got to look at something. I mean, it can't be that the hearing officer has to accept whatever evidence it is that the petitioner files, correct?
Correct. But again, and the analysis relative to the substantial evidence standard is really not quite the same. It really goes more to the quantum of evidence. Again, what's at issue here in this case, with respect to this issue, is the processing of these cases and the fact that, as Judge Kane found in this case, that it really truly does leave a wide array of discretion. We don't know. I mean, there's this multiplicity of factors. A judge in any given, or strike that, a board examiner in any given case could be giving greater weight to factors 1 through 4, lesser weight to factor 5, greater weight to factors 6 through 10, et cetera, as was touched upon earlier. The problems, and I think Judge Kane touched on these in his decision. Also, besides the aspect of review of the administrative decision by the Superior Court judge, another factor here is disparate treatment, which again goes to the weighing of those factors. Another problem is the offender faces a prejudice because of the difficulty in challenging the initial classification under the current system.
Let me just, if I can, go to the regulation. At the present time, the hearing examiner, we've got a whole bunch of steps, and if the petitioner, the offender, challenges, you get a new hearing examiner decision, and then in reaching a decision, shall consider the relevant credible evidence and reasonable inferences to determine. And didn't this hearing examiner go through and try to explain what he had considered?
True, but again, as the Superior Court judge's concerns illustrate, we simply don't know what methodology was used. And again, yes, it's true that fact finders or adjudicators under our systems are not always required to utilize actuarially based tools. But again, this is the difference here is we're dealing with the classification of people and the stigma, all of the stigmas that are attached, which indeed, as was touched on in the case here earlier this morning, once then the federal system is set in that folks could be, even level 1 folks could be dealing with this for the rest of their lives. And the whole line of Doe and Roe cases from this court I think has made it explicitly clear that that there are very substantial liberty interests involved.
Mr. Smith, I want to make sure I understand your argument. You don't disagree that the board explains what the factors are that they are looking at, but you're saying they don't tell you how much weight they're giving any one particular factor.
Correct.
That's
correct.
your position.
I mean, in fairness to the board, every case that I have dealt with, they do a very good job in setting forth in the abstract what those statutory and regulatory factors are. I believe the regulations mirror the statutory factors. No question about that. But again, the problem, the immensely disconcerting problem here is the application of those factors to any given former offender.
Mr. Smith, it may be that, like Justice Cordy, I haven't parsed the record or haven't understood it when I've tried to, and I'm not faulting Judge Kane at all, because he obviously, when you're asking him to conduct a 30A review, he's trying to do the best that he can, and he says, essentially, I don't know how to review this, because it's this hearing examiner's impression, but we have worksheets, and everybody seems to agree that this was borderline. Even if we did adopt your system or the one by the amicus, wouldn't we get borderline situations?
That may very well be the case, but I think what Matthews versus Eldridge, I think implicitly at least recognizes is we can't have a perfect system with respect to each and every case. That simply is not possible under any paradigm. But again, I think that if you look at the literature, especially that Hansen and Bussiere meta-analysis of all of the other literature, I think it's clear that such a system results in a far greater, far more accurate predictive model than what we now have.
Is that what Judge Kane is talking about when he talks about the utilization of objective standards as presumptive guidelines? I mean,
correct. And I had, Your Honor, made that distinction, I believe, in my brief, or at least in a footnote, that the parlance might be different, but that is indeed what
you were talking to him about that?
I'm sorry.
Were you counsel before Judge Kane?
No, I was not. Okay. That was a different lawyer. And so again, I'd like to reiterate that it isn't just a question. I most certainly am not standing here and saying that the legislature made its decision and the decision was not good enough. Again, I would suggest that it all comes down to the Matthews v. Eldridge analysis. Interestingly, here as well, on the other side of the sort of analysis, the Eldridge analysis. One of the factors that certainly is supposed to be considered is the burden or the cost to the state. Interestingly enough, were this actuarially...
That's the third factor, and there doesn't seem to be a huge fight over that.
Well, my brother did mention...
You're going to tell me it would be cheaper for the state to do it your way.
It may indeed be cheaper. It may be more efficient. It may result in more rapid processing of these cases.
Well, the sentencing guidelines are our goal here. That hardly decreased the cost of litigation.
Well, that may be the case. That's the federal sentencing guidelines certainly were a totally different result in their application.
And so what we have in Massachusetts are guidelines.
Correct.
Guidelines. Anyway, thank you.
Thank you very
Mr.
much.
Smith.